Parties need to understand that each project, each generation project that they're going to embark upon is fairly unique. And I think what experienced lawyers bring to a project is really a firm understanding of the entire cycle involved in undertaking a project. And that includes from the moment you walk in the door looking at the possible structuring of the corporate entity and the tax structure, to site acquisition, through to the various contracting and permit regimes that are required, including power purchase agreements, construction contracts, and then through to financing and beyond. Doing any project, including a generating project, is really not dissimilar to running the obstacle course. Each obstacle will require you to jump over, under, go under, requires different skill sets to get past that obstacle and to get to the finish line. There's a good many lawyers that are in the field that deal with generating projects. While a number of these lawyers are really good at determining and providing sort of feedback on the issues and permits, for example, that party needs to obtain, good counsel, experienced counsel provide the ability and skill sets necessary to get over, under, or sideways, go around the obstacle in order to get to the finish line, whether that's through providing the direct skills necessary or simply the coaching. In each case, that's what good experienced counsel do. I think the first most common pitfall that most parties would identify is sort of the siting risk associated with the location of a generating project and the NIMBYism that goes along with it. There is no way that you will not have NIMBY types of issues associated with your project. But what I find is that most clients, developers, don't understand that there are ways to sort of reduce the effect of NIMBYism through effective and strong stakeholdering and consultation. The very best developers I've worked with understand the need to get in there early, to communicate frequently and consistently, and not just when permits are required or certain public consultations required. They do it on an ongoing basis. And while this does not eliminate opposition totally, what it does do is reduce the level of opposition and reduces the level of miscommunication that there is out there about the project that you're undertaking and what the effects of that project might be on the local community and the neighbors around it. That by far is the most effective way to sort of reduce the risk associated with NIMBYism. From a legal perspective, people need to recognize that Aboriginal First Nations have additional rights that have been afforded to them by the Supreme Court of Canada. So the duty consult requirement has been a game changer in terms of developing projects. Developers need to understand that there is a duty to consult with the Aboriginal First Nations. Developers often think that if they've signed a participation agreement or a benefits agreement with the First Nation, that their duty to consult has ceased to exist, when in fact, really, it continues on. It's important to understand that the complexion of the relationship with First Nations has changed. First Nations are looking for meaningful participation in these projects, not simply employment and jobs, but are looking more for participation in the project itself. So the duty to consult and the relationship with the First Nations are absolutely critical to the success of any sort of new project, generating project. Power purchase agreements have developed throughout Canada and are fairly well developed at this stage. Many of the power purchase agreements we either see in standard offer contracts, or power purchase agreements that have been drafted for the purposes of RFPs, requests for proposals. Since they are relatively well formed, it is really difficult to have changes made to a particular power purchase agreement. What experienced lawyers, however, bring to the table is a good understanding of the genesis of those power purchase agreements and standard offer contracts. Understanding the basis of these power purchase agreements separates good counsel from average counsel in terms of assisting clients in negotiating these power purchase agreements where negotiations are possible. The key issue for parties to understand, clients to understand, is it's not only that you should be looking for experienced lawyers, you should be looking for lawyers that are busy. And if a lawyer is busy, it generally means that not only are they experienced, but they understand what's going on in the marketplace currently. None of the contracts we work on stay the same. There's always developments going on, there are trends, there are movements. So experience in and of itself is not enough. Being busy suggests that the party is aware of what's going on and can provide you with the most timely and up-to-date advice in terms of the things that you're going to have to address.